Okay, so today is going to be basically the introduction to what these individual fraud cases are, what it means. This will be a really good way for everybody to decide whether or not their case fits into the parameters of what we're trying to do for the fraud project. My name is Christy Merrill. I am not an attorney. I do not give legal advice. I can tell you what I know, I can tell you what I've learned, and I can tell you what I've been through. So the purpose of the fraud project, first of all, is that every one of our cases actually satisfies every single parameter in most cases for fraud on the court, and that naturally also satisfies RICO racketeering. And so the goal that I have and the thing that I want to see happen is that we flood the federal courts, like I've said before, with these perfectly validated federal fraud on the court complaints. And so a lot of what we have encountered is attorneys, judges, etc., CPS, blah blah blah, different actors in these things telling us that there is absolutely nothing we can do, and that is absolutely false. Okay, so just to reintroduce myself a little bit, I spent 8 years researching this solution. Now, I want everybody to understand that I wrote everything down, and I'm going to be reading it, so please excuse my video quality, my hair. I don't care, with all due respect to anybody. I'm going to present myself the way that the Lord set me out to present myself, which is as myself. And I'm doing this the best way that I know how. So as I said, now everything that I post in this group, like I said, I actually wrote it out, and I'm going to read it so I stay on task and on topic. But I'm also going to post the actual written portion of it in the files in the group as well, and it'll be well organized. But the first thing that I wanted to address, and I realize this is going to take a minute, but I need everybody to follow this entire video, because the problem that we have encountered is that there is an actual recipe, as I keep saying, for this, and so today that's what I'm going to address, is why the cases have not been working before now, and what needs to be a part of the case, what the case pieces mean. And I'm doing it as a video so you can pause, so you can take notes, whatever you need to do. I'm posting the written portion of it so that you can also further study that for your own abilities and knowledge later as well. So anyway, getting started. The federal fraud on the court recipe. Law is like a recipe, okay? It doesn't matter how passionate you are. It doesn't matter how obvious the injustice seems or how deeply you are harmed. If the legal ingredients for your case are missing in the case, written down in the case, the recipe fails. So, I've had a lot of people say to me, well, the judge that I filed blah 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 with should have been able to see, and that's true, but the judges don't have the right to do that, the legal right to do that. The things that we have that have to be satisfied in our cases have to literally be written out and addressed with evidence. Now, a fraud on the court cases is not any different. If you don't have the right ingredients, it's either going to be dismissed straight out of the gate, or it's going to be ignored, or whatever. It is a precise combination of factual elements, doctrinal elements, jurisdictional elements, and procedural elements, okay? And don't let the language get overwhelming, because I'm going somewhere with this. Every ingredient must be present, must be measured correctly, and combined in the right order to get your final product, your federal case, to rise, okay? So we're gonna take all the overwhelming junk out, and we're gonna think of this in terms of a recipe. When all the ingredients are present, the case becomes structurally sound, which is what I did this for, is to make sure that we have these elements satisfied. We want a structurally sound case, a jurisdictionally valid case, and legally undeniable. That's where people have been mistaught by all the people that don't want us to figure this out. When we present the proper case, The judge has no choice but to do what we're asking them to do. Anyway, when even one ingredient is missing, the case collapses. Okay? The recipe that I'm giving you right now is a narrative explanation of each required element, why it matters, and how it fits into the larger structure of federal fraud on the court litigation. Every fraud on the court case begins with proof that the judicial process itself was corrupted. So what I want to say is, and I'm going to, of course, repeat myself a few times, so forgive me for that, but this is very, very valid and important. There is absolutely so many cases in this country of people perjuring themselves. And I want to tell you that perjury is not what defines fraud on a case. That right there is one of the most important pieces of information I'm going to give you today. Okay, so check this out. Every fraud on the court case begins with proof that the judicial process itself was corrupted. This is the heart of the recipe. This is the flour. Without it, nothing else matters. Fraud on the court is not about ordinary lying or perjury. It is about the court being used as a weapon, not a neutral decision maker. Hazel Atlas Glass Company versus Hartford Empire Company describes fraud on the court as wrong against the institutions set up to protect and safeguard the public. That line, which is within the case itself, if you look it up, captures the gravity of what must be shown in our cases. The judicial machinery itself was compromised. Our cases were not able to be legally decided because there was no justice involved in the case from its inception. Anyway, this corruption can take many forms. Fabricated evidence, concealed reports, ghost-written evaluations, ex parte communications. This is a big one. ADA, Americans with Disability Act 2010, violating procedures, denial of notice, or denial of meaningful participation. And that's a big one, is the denial of meaningful participation. The process was not corrupted. If the process was not corrupted, the recipe fails before it begins. That being said, so one of the things I want to also point out is that in every case where there is ineffective counsel that was provided to you by the state, or you didn't have an opportunity for a lawyer, that absolutely is very, very relevant to each one of these fraud on the court cases. Anyway, all right, to satisfy fraud on the court, an officer of the court must be involved, okay? What that means is, fraud on the court requires the involvement of someone who acts as a part of the judicial machinery. This is the yeast, the ingredient, right, that makes the case rise above ordinary misconduct. Hazel Atlas Glass and Demanjanuk, anyway, I have a hard time sometimes with the names, but I'll put the references, obviously, in here under the video. But anyway, in the description. So, these two cases both emphasize that the fraud on the court requires insider involvement, aka people inside. You were an outsider. So insider meaning CPS, it means the assistant county attorneys, district attorneys, the opposing counsel if it's a divorce case. It includes obviously the judge. I mean, it has to be it could be the clerk of the court, okay? But anyway, it has to include an officer of the court process itself to qualify under the federal court fraud on the court case. Okay, a private lie, aka perjury, is not enough. A corrupter is inside the court process that makes this fraud on the court. Okay, officers of the court include GALs, judges, CPS workers, court-appointed evaluators, aka the therapists, attorneys, clerks, and other court-connected professionals. When these insiders manipulate evidence, conceal information, or engage in deception, the judicial process becomes structurally unsound. And what we're trying to prove, because the point of this whole thing is to prove that the judicial process itself became structurally unsound and was not, and that's what makes our cases a legal nullity or void ab initio, and that's the difference between the fraud on the court case and an appeal or anything like that. And so anyway, this ingredient of officers on the court corrupting the judicial machinery of the court case against you itself, that is mandatory. Without an insider, at least one person inside that case working against you maliciously, then the fraud does not reach the level required for a federal intervention. Okay. Extrinsic fraud. I have mentioned extrinsic fraud before, and we're gonna go into this a little bit. Extrinsic fraud is the federal key for these cases. Okay, extrinsic fraud is what establishes subject matter jurisdiction for the federal court. I want you to write that down. Extrinsic fraud in your case is what establishes subject matter jurisdiction in our federal fraud on the court cases. Extrinsic fraud is the federal key, the ingredient that opens the courthouse door. Okay? It is the difference between disagreeing with a ruling and being denied a fair chance to defend yourself. And these are the concepts that I'm trying to help everybody understand. Extrinsic fraud occurs when a party is prevented from presenting their case. So that's a due process thing, you already know, because in this country we have the right to due process, which includes the ability to face our accuser. Kugassian versus TMSL states plainly, this is one of the case laws I'm going to reference, a plaintiff may bring a federal action alleging extrinsic fraud on a state court. That sentence is the gateway to federal subject matter jurisdiction that is essential in our cases. Extrinsic fraud includes a lack of notice, hidden reports, secret communications, denial of ADA accommodations, fabricated evidence never disclosed, coercion, and check that last one, coercion, because we were all coerced into taking pleas, etc., threatened, blah, 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 and refusal to allow cross-examination. If extrinsic fraud is missing, the case is usually dead on arrival, aka if there is no literal statement with cited corroborated case law pointing out that extrinsic fraud in our federal fraud on the court cases was committed against you, then the judge is going to automatically kick the case out. It is the yeast that makes the entire recipe rise. Okay. The injury must be independent of the state judgment. Here is the key, all right, one of the many keys, but it is a key. We have talked about the Rooker-Feldman doctrine, and according to the way that we have to survive it, because a lot of these are coming from family court-related cases, to survive Rooker-Feldman, the injury done to you that we're presenting in our case must come from the fraud itself. Okay? We, once again, are not asking the judge to reverse the judgment, to dismiss the judgment. We're not asking any of that. The judgment, if we satisfy Rooker-Feldman doctrine, is absolutely irrelevant, because what we're alleging is that the state action was taken against us in the first place without proper jurisdiction, okay, without it being a valid case at all. So we're not asking for the substance or the judgment to be adjudicated on by the federal judge. We are asking for the judge to look at the fraud itself that injured us, okay? That is to say, in my case, the judge created a federal case, or excuse me, a state case against me that caused continuous retaliation, illegal adoption, etc. What I want to address is the retaliation, the silencing, the illegal adoption as a result of what she did, and the harm that came to my children. So we're taking the case itself and setting it aside and saying it's not the judgment the courts made against me that I need you to fix. It's the fact that the courts did not have a right to make any judgment because they didn't follow the laws to do that. Okay, this is the sugar, the ingredient that balances the recipe and prevents it from collapsing under judicial scrutiny. Okay, The Great Western Mining and Mineral Company versus Fox Rothschild, check that last name, LLP, explains that the federal courts have jurisdiction when the injury is caused by the defendant's actions, and the defendants are all the court actors that took these things out on us in the first place. The defendant's actions and not by the state court judgment. This means that the plaintiff must show that the harm came from fraud, concealment, ADA violations, due process violations, or equal protection violations, not from losing custody or from receiving an unfavorable order. So we're framing our mind with the proper parameters right now of the federal court. This ingredient ensures that the case is not treated as a disguised appeal. Okay? This is not an appeal that we're sending up to federal courts. That's not what we're doing at all. In fact, it's quite different from that. We are going after, which again is what gets rid of the judicial and quasi-immunity, the fact that these people acted outside of their roles, period, to do what they did in the first place. Now, the plaintiff must not ask for the federal courts to overturn the state judgment against them. Framing is everything, okay? You cannot ask the federal court to change custody, modify visitation, or vacate state orders. Doing so will literally poison the recipe against you. So the judge will see that if you ask that, if you frame it that way, and it will be an automatic dismissal, okay? Instead, we must ask for relief federal courts can grant. Number one, damages, as I've said before, declaratory relief, prospective relief, ADA enforcement, policy changes or training requirements, and in the case of the fraud project, we're going to be asking for things like writs, extraordinary writs. The federal court has the ability to give us and grant extraordinary writs that will require these courts that ruled against us and the actors in it to not only leave us alone, but to stop from taking further actions against us. So we're going to be literally asking for protection. One of the abilities that the federal court has is very simply for us to ask for these things to be referred to federal DOJ and federal FBI to report public corruption, and that's what we're going to do. Anyway, so ExxonMobil Corp versus Saudi Basic Industries Corp teaches that the Rooker-Feldman doctrine is narrow, but it becomes broad, okay, the moment a plaintiff asks for custody changes. So, repeat after me, and then write it down. Get it thick through your head, all right? Plaintiff does not seek review or reversal of any state court judgment. That is one of the mandatory ingredients in our court cases. You have to actually list, plaintiff does not seek review or reversal of any state court judgments. That is the key to your case moving past the part to the point that the judge is actually going to look at it, okay? This framing protects the case from dismissal, all right? Now, next. The defendant must be a state actor or state-connected actor, aka the defendants, the respondents. So yeah, the defendant in my case, one of them is the judge, all right? And I'm going to tell you right now, she is the state president for circuit court judges in the state of Kentucky. Here's how this works. We are going to either go big or go home. It's up to you guys. But this case that we're taking out and putting in the federal court is a case against these people that honestly believe they have no oversight to keep them from violating our rights. So we're going to be listing judges, we're going to be listing attorneys, we're going to be listing county attorneys, district attorneys, Commonwealth or state attorneys, whichever it was that was involved in your case. We're going to be listing GALs, we're going to be listing every possible state actor involved in our case. Because if we don't, then obviously you already know. They're just going to keep doing what they do. Anyway, so for 1983 liability, which is a Monell complaint, and we're going to address that in this group as well, just not at this exact moment, the defendant must act under color of state law. So 1983 is a deprivation of rights under the color of law, right? We each have that same case. We have a case of that. We have a case of fraud on the court. This is the salt, people. The ingredient that activates everything else, okay? State actors include, as I said, CPS, GALs, evaluators, county agencies, judges for non-immune acts, which is what we're accusing them of, is non-immune acts, etc. And private actors can be liable, meaning the therapist, etc. Well, meaning everybody. Anyone, any private person that involved themselves in the fraud on your case, be it your ex-husband, for example, your ex-wife, for example, if they also conspired, they need to be listed. Private actors can also be liable if they conspire with state actors. So basically, if we were to speak about this in a spiritual way, I would very simply say, this is a take it all back moment. Tauren Wells, good song. Ziklag, if you want to look it up in the Bible, where they came back and everything was ashes, the entire city, right? King David and his men and all their wives and children were stolen, and everything they owned had been burned to the ground and looted. So what David did, right, was always ask the Lord what his next move was. And that is what blesses this move, by the way. David said to the Lord, he said, shall I pursue them? And when he said them, he literally meant everybody who had done this against him, right? So, and the Lord's answer to him was, pursue them, you will overtake them, I will guarantee you victory, and I will give you the spoils of war. This is exactly what we're about to do. And like I said, when we flood the federal courts with these, with all the correct ingredients, they cannot ignore us anymore. So anyway, all right, back to what we were doing. So, private actors can also be liable if they conspire with state actors. Dennis versus Sparks, write that one down, confirms that private parties who collude with judges or state officials can be sued under 1983, commonly known as Monell. This ingredient ensures that the case has the viable defendants who can be held accountable. Next, a federal right must be violated. Okay, so one more time, what I'm going to try to teach in this process is how every single ingredient has to be correctly named, like physically out loud named. This is going to be easier than you think, trust me, because I already did all the work. But anyway, it has to be physically named in the actual court documents themselves for it to be recognized by the judge. So, fraud on the court must include at least one federal right violation. These rights are the eggs that bind the entire recipe together, right? The most common federal rights in these cases are due process, number one. Devereaux v. Abbey confirms the fabrication of evidence violates due process, okay? Equal protection, this is discriminatory treatment that violates the 14th Amendment. Equal protection, I keep saying this thing, categorical ban out loud, and I want to tell you what that means real quick. So a categorical ban is when a state actor, aka CPS, or even a judge would say, hey, you know what, this person's disabled and so they won't be able to take care of their kids. First of all, nope, that's not how that works, all right? That violates so many laws in and of itself, and that's fine, but when they say a disabled person, the categorical ban that they're trying to use is that because this person is disabled, they can't, and that will not uphold in federal court, period. In fact, it will be seen as part of the fraud that was committed, because categorical bans have been like absolutely, they're illegal. They've been instructed against. So it's going to be seen if that was one of the things that was done to you. So we're going to have to list that under the equal protection discriminatory treatment that violates the 14th Amendment. Okay, so ADA Title II, on that note, by the way, Tennessee versus Lane states that access to courts is a fundamental right, which means that if these things were done to you and your disability rights were violated, and the court was aware of your disability, then you absolutely have a case based on that alone, especially for damages. Family integrity. Santosky v. Kramer. You guys need to really familiarize yourself with that one for sure, because Santosky v. Kramer calls parental rights commanding. So what that is to say is that there is a understanding in law that parental rights, first of all, we have the liberty to exercising our parental rights without the involvement of the government. But on top of that, it is supposed to be understood in these courts that the first thought in the mind of a parent is in the best interest of their child. Okay, these cases have already established what we already understand and need to present to the courts in this particular recipe. So Santosky v. Kramer, look that one up. Anyway, without federal rights violations like the violations of the things I just listed, there is no case. Okay, there must be evidence of fabrication or concealment. Fraud on the court requires proof. If you need help figuring out what proof you need, under the video when I post it, either write something to me or whatever, message me, whatever it is, we'll figure it out, because everybody has proof of fraud, whether they realize it or not, and that's what I'm good at, is finding the proof. Fraud on the court requires proof. This is the butter, the ingredient that gives the recipe substance. All right. The evidence may include falsified reports, hidden evaluations, manipulated evidence, ghost written documents, altered records, or withheld exculpatory information. Demanjanjuk, that is the name of the case I was trying to list earlier, is an authority for concealment. Hazel Atlas is the authority for fabrication. Fraud on the court is not a feeling. It is a provable act. And I guarantee if you have the feeling, then there is actual evidence that you already have in your possession to corroborate that. So, next, the fraud on the court that we are alleging, this is one of the ingredients, it must affect the judgment that the state court gave. So even though we're not asking them to reverse the judgment, all right, there must be a clear causal connection between the fraud and the outcome. So, in my case, the judge that I was dealing with did not like the fact that she could not do the political favor she had been asked to do prior to her creating the case, okay? Because I had in place a DVO against someone rightly to keep my children and I protected. So the creation of the case the way she did it was for the purpose of getting the outcome that she wanted and that she'd been asked to give as a personal and political favor. So, let me read this again. There must be a clear causal connection between the fraud and the outcome. This is the baking powder, the ingredient that makes the fraud rise into a federal claim. You must show that the judge relied on the fraudulent material, the fraud that influenced the outcome, or that the fraud prevented a fair hearing. Now, in my case, just to give you an example, I didn't get a fair hearing because the case was created on a fabrication in the first place, all right? And so anyway, without causation, meaning unless you can prove that part, that the fraud itself caused the issue, right? The fraud is legally irrelevant, all right? And we don't have to worry about that, by the way, but defendants must not be immune. How is it that people are losing all these really good, absolutely proven fraud with evidence court cases, period, that they're filing? It's because they are not physically writing in these cases why judicial and other immunity does not apply, okay? So, defendants must not be immune. A fraud on the court case must target defendants who can actually be sued. Judges are immune for judicial acts. GALs are immune for judicial functions, but they are not immune for investigative misconduct, fabrication, concealment, ADA violations, constitutional rights violations, or acting outside their appointment. So when we write our cases, one of the most important sections of it is going to be the part where we actually write out the judge does not have judicial immunity in this case because she clearly violated blah blah blah. Like, you have to actually write that out. And so anyway, all right. CPS workers, evaluators, therapists, county agencies, and private attorneys are generally not immune. This ingredient ensures that the case has viable defendants. So we're going to go through later why quasi-immunity and the immunity of these other people besides just the judges does not apply, and how to list it in our case. So anyway, the complaint must include proper federal claims. Okay. A fraud on the court case must include the correct legal claims. These are the spices. Each adds a necessary legal flavor. The complaint should include 1983 due process claims. We all have them. Okay? 1983 equal protection claims. We all have them. Fraud on the court claims. Conspiracy claims. Monell claims for county liability. These claims transform the narrative into a legally actionable case. That's the key, is that I'm trying to teach you how to have a legally actionable case. Because if you have a legally actionable case and all the ingredients are present in the recipe, then there is no option, and I mean literally no option, for the federal courts to not intervene. Okay. The plaintiff must request relief federal courts can grant, like we talked about before: damages, declaratory relief, prospective relief, ADA compliance orders, policy changes, or training requirements. Asking for custody changes ruins the recipe. We've talked about that. Okay. Federal courts do not modify family court orders. They remedy federal injuries. That is what we are doing here. We are addressing the fact that all of our rights were violated. Okay? We're not addressing the fact that we need the state to overturn or reverse a judgment. We're addressing the fact that we need to be paid for all the harm that was done because they refused to follow the law. This is an accountability process. The Fraud Project is an accountability project. Okay? These people believe that they are not suable. They believe that they have the immunity they need to get around this. They believe that we're not smart enough to be able to figure this out. And this is the moment where we show them that they are going to be accountable to the people, and especially to the children whose rights they have violated. Anyway, next, jurisdiction and venue must be proper. The case must be filed in the correct federal district with proper jurisdictional and venue statements. This is what I mean when I say we have to get everything written properly in these cases. It's not hard. Everything that I've listed off so far is approximately a paragraph, usually a small paragraph. This is the oven temperature. Wrong temperature, wrong result. So, if you do not know where to file your case at, where to go to the clerk's office to file it, reach out. We will all help you. We will all help you find the right place. That being said, I also want to just point out that, the headings that these courts require and things like that, they're easily findable online, and so it's not going to be difficult. Okay, so let me give you an example of what I mean, just so you have a working idea of what I'm talking about. When we file these, let's say I was to file a federal case, then I would look up federal case. Then I would look up my city, my county, whatever, and my state. It would come up with Western District of Kentucky, Owensboro Division, and so I would then look up what the headers should look like, so that I could place it correctly on the top of my document before I file it. We'll get into that later, but anyway. The narrative must be coherent, okay? One of the biggest problems that we have had is that so much emotional damage has been done to us, so much trauma, that we are almost unable to even really coherently talk about what's happened. That was why the timeline process that I asked everybody to do, write down the narrative from the beginning fix it however many times you need to, but write down the narrative chronologically from the beginning of what happened to you, because a lot of us haven't had that processing time and the ability to do that. So one of the concerns, obviously, that there is in this process is that we won't be able to correctly state out loud to the federal judge the order in which everything happened and what the story actually is. So that would be the reason that I came up with this remedy, so that we can coherently tell people now what is going on. A fraud on the court case must tell a clear, compelling story. What did it? Who did it? What happened? How it corrupted the process? How it violated federal rights? How it harmed the plaintiff? How it fits federal jurisdiction? This is the presentation. The judges must be able to read it like a recipe to be able to go bake the same cake, people. We got this. The case must be cleanly separated from custody issues. The plaintiff must repeatedly state that we are not seeking custody changes, because we're not. We're going big or go home here. We're not seeking that. We're seeking a whole entirely different remedy, which means that we're trying to prove that the people that did this in the first place, specifically the judges that allowed it, that they didn't have a right to rule. So there was no case to begin with. I'm not trying to be yucky, but if we present facts and we present them publicly, then real stuff, if it embarrasses these people, and I hope it does, and they lose their bar licenses and their benches, then we've done what we set out to do. Period. The end. Okay. Anyway, sorry. I will get fire about this. The plaintiff must repeatedly state they're not seeking custody changes. This protects the case from Rooker-Feldman dismissal. And I'm going to teach you to include this state in the introduction, the jurisdiction section, and the relief section, because those are most important places for us to over and over tell the federal judge we are not seeking to modify custody. Anyway, so administrative remedies should be exhausted, which is optional but not helpful, or which is optional but helpful. Judicial conduct complaints, bar complaints, ADA grievances, and agency complaints show that the plaintiff attempted to resolve issues before filing federally. This ingredient is optional, but I guarantee it'll strengthen every case we have. Now, what I need to say about that is this. In the structure that I set up, the fraud project, that is something that's going to be done when we're done writing the federal case. Then we're going to submit those the judicial conduct complaints, bar complaints, and any other necessary complaints. I know that 99% of these cases, you guys have already done that. So one of the things I need you to print out as evidence and have accessible is all the ombudsman, inspector general, attorney general. It doesn't matter what it was. Every single way that you attempted to find oversight that was not given to you, we are going to include that in our cases as proof that we've done literally everything we can do on our part, and it is still not being dealt with, which is what's going to give our cases what it needs. Now, the case must be timely. The fraud on the court is not subject to normal statutes of limitations, but 1983 and ADA claims are. Filing must be timely. This is the timing ingredient, even if even a perfect recipe fails if it's baked too late. That is to say, but there are exceptions. So anybody who heard that and got worried, don't worry about that. All right. What we're here to show is that in a lot of our cases, there was some pretty extreme retaliation done against us, gang stalking. I don't know what you want to call it. You can call it what you want to. But because of that, we can show that until this moment, we didn't have what we needed to be able to present the case based on the things that were being done to harm us. And so, anyway, every ingredient must be present, every element must be satisfied, every doctrinal requirement must be met, every jurisdictional barrier must be addressed, every immunity issue must be navigated, every federal right must be clearly violated, every fraud episode must be proven. When all the ingredients are present, and then the case becomes structurally sound, jurisdictionally valid, and legally undeniable. Okay? It sounds scary, but I'm going to tell you something that's actually pretty important. when we are looking at these cases, you already know pretty much every bit of the information that you're going to be presenting in this very well for each subsection I already listed. Okay, you already have an idea of what happened. We're going to be presenting as much as possible the recipe I just listed with one paragraph and then corroborating evidence. We are pro se filers, so we are not going to have to do this too fancy, and this is going to need to be in your voice. So, not to keep repeating myself, but I need you to make sure that timeline's done. That narrative timeline that I asked for, and I asked for 2 separate timelines, the narrative timeline and the outline form, okay? This narrative timeline is basically the same thing as your affidavit. It's what makes this process be able to be in your voice. Every last one of us has had our voice stolen. And what I would like to do, the Lord and I together, is help restore your voice. You still have a voice. You just need to know how to use it. I'm here to help you properly weaponize it into a legal format. So anyway, that's introduction. I have a 9-day step-by-step process that I'm gonna teach. 9 days ain't bad. We got this. As long as everybody's willing to go big or go home, I just want everybody to understand I'm praying for you. I believe you. And not only do I believe you, but I've been there myself. There is no part of this that should have ever happened to any of us. And it's up to us to go rescue our kids. We're gonna do that. And anyway, I hope everybody has a good day, and I'll see you again soon.